Hi, welcome back to the House Judiciary Committee and turning our attention to S 209. And there's just one change given, one proposed change that is language I proposed and had Rick draft up, given some of the testimony and discussion that we had yesterday. It's on page 2 and it's regarding buildings. It significantly, I will admit, narrows what buildings would be under this restriction. And the language is building owned and wholly controlled by the state or a political subdivision of the state where members of the public may enter in order to conduct governmental business. I mean, it doesn't include specific, I mean, it very much wouldn't include the National Life building or equivalent kind of facilities that are leased or rented. I recognize that this does, like, again, I significantly narrows this, but I think it gets at some of, it would include like the State House, for instance, and other kind of obvious state and political subdivision buildings. Yeah, Ken.
What's political subdivision?
It's appears in 100 different places in our statutes. I think 56 places it does define it, and it would be towns, cities, municipalities. It's my understanding. It includes, you know, that's in villages.
So is there like a breakdown of like certain buildings that you can give me a for instance on, or like that's town hall, or
I mean, if it's
municipal
just
building?
if it's owned by the municipality or the subdivision, and they fully control it, then yes. If it's like a municipal office that's being leased or rented from someplace else, this doesn't cover it.
And that members of the public may enter.
And it's, yeah, and it has to be places where the public can enter.
Thank you.
So it's to try to address, it gets, what I was kind of hearing from folks is that it gets very complicated as far as knowing where this provision would apply and where it wouldn't. And I think this is the best way to really narrow it to what people should know our state buildings. And again, I know that it doesn't necessarily include everything we'd like to see it include, but it does go a step further than what we received from the Senate. Yes, Andrew.
Yeah, I would just say that I acknowledge that as well, that it's slightly it narrows from where we were a couple days ago, but that when we're holding a few different truths at the same time, this makes a lot of sense to me. So knowing that it's important that the law be sort of easily understood by the folks who would be affected, this makes more sense to me. I don't think that we're going too far if we think that, you know, that we can expect federal agents to know if a building is, you know, if the state is leasing office space and what that all means, you know, like I just appreciate the straightforward nature of this language. And I think it's an improvement, even though I recognize it's a narrowing.
Yeah, it's definitely a compromise. And I think I just want to put voice to the fact that it is smaller and less wealthy communities that are going to have municipal and state buildings that are not state owned and are rented. And that the narrowing of this language is going to impact those communities more than larger communities. And so that said, I really do get why we need to narrow the language to get it to a place that actually is workable. So I think it is a compromise that I support.
Your timing is perfect.
Yeah, it's pretty imperfect, actually.
Perfectly imperfect.
I think I just heard federal authorities. This is a federal authority bill only?
No, not as it is right now, it would apply, but my understanding is there really aren't civil arrests that are made without a warrant or order by state or local law enforcement. So in effect, it really is applying federal. So, but let's hear, I think
So can I
that
just ask one more question?
can you hold that question? Because we don't have Jay for very long, and I just wanted her to touch base on the building issue. And there's some language, and if you can give, we've changed the language slightly from, well, not slightly, I think significantly from when what we sent to you. And
Okay.
and if you could see, yeah, but yeah, I would think it's, I would assume largely the same testimony that you may have for us, but
Asking about also local. They enter in order to conduct governmental business. Okay.
and if you're not prepared to because this is new language, it narrows pretty significantly from the language we had before. So it takes out rented or leased property. It makes clear, I mean, these are the pretty clear federal buildings, like the pavilion, like here.
Yeah.
State buildings, or a wholly owned municipal clerk's office. So,
Right.
but you can give us kind of the broader, just the pros or cons, or whatever, however you want to weigh in this. And thank you for
Oh, yeah, no, thank you for inviting me. Again, Jay Pershing Johnson, Governor Scott's legal counsel. So I guess my thoughts largely come from BGS, which essentially makes the point that we don't have personnel, sort of at manning the desk of every state building. This says may enter in order to conduct governmental business. We have lots of locked buildings where people have to be, buzzed in. I think that's a lot of AHS, maybe district offices. And then you have other kinds of state buildings where I think it's even true, like you can walk into the pavilion, but you can't go upstairs. You can you can't get into, say, the building where state attorneys and sheriffs are located. You need badge access, so they let you in. But to the extent that you are able to badge in, just because you're a member of the public and you show up at the door and there is a receptionist or somebody there, they are not necessarily security. They may be just an administrative person sitting at the desk, not trained for anything except to say, hello, who are you here to see? And they'll probably they may ask, I know in public safety's building, you go into their building and you can enter the lobby. There's a person sitting behind a glass wall and they say, we have your ID, which they can go on to while you're visiting. And who are you here to see? And then that person comes to get you. So there's all kinds of different ways that people access state buildings. Here, obviously, you can walk in the door and walk down the hall and, it's public. It's the people's house. So, so with those constraints, it would be very hard to sort of, how would this be implemented in a state building? Is one question. Like, what does this mean if the intent is to address the fears of individuals who are not going to a state building because they may be arrested? How does this address those fears? What if the ICE person is waiting in the lobby and the person, whatever, their subject walks in and they arrest them with their administrative warrant? What is that person at the desk supposed to do at that point? Do they call local law enforcement? Do they call their supervisor? And they say to the ICE agent, I'm sorry, can you hold one sec? It would seem to me that because this is going to require a ticket, you're going to have to call local law enforcement.
So this doesn't require a ticket, this one,
Oh, it doesn't?
yeah, no, this is,
So just a shall not?
the remedies are either I know remedies here. So it's at the bottom of page 3.
The AG's office can bring a civil action. for
It's a
relief.
civil action for, yeah, it's not a criminal action there, and it's a private right of action on subdivision B and enforcement authority in the Attorney General's office in subdivision C. So essentially, the scenario, as I understand it, Jay, is that if that were to happen in a building, the person who was arrested would have a cause of action, or the Attorney General's office would bring an action. So I don't think
So you
there'd
don't
be,
call the police.
yeah, I don't
Person
think the
says-
expectation of
So
that.
the person is detained by ICE. They get taken to the ICE facility and sent to Texas. And then they call the Attorney General's office, who is then supposed to issue an injunctive relief against ICE for performing their legal function in Vermont. So anyway, there's logistical issues with what is that person supposed to do? And not every person has access to every building, and there isn't always somebody staffing it. And the person staffing it may or may not be security. And it's very unlikely that, like in the State House, you have certified law enforcement. We don't have that in our buildings. So, and in a courtroom, you would, I guess you'd have a sheriff, and you would have obviously Capitol Police here. But I do run into then that sort of federal question that the Ninth Circuit brought sort of into high relief, which is, don't you run into the same problem? The state is actually trying to criminalize, or not criminalize, penalize the exercise of a federal law enforcement, the lawful exercise of a federal law enforcement function. And while it's spread across all of the different law enforcement agencies, it's irrelevant, according to the Ninth Circuit. Also, we can't harbor, and we can't impede, and we can't prohibit anyone with communicating from communicating with a federal officer. So I guess my first concern would be sort of one raised on behalf of just the operations folks. What are they supposed to do? What is our policy supposed to look like? And actually, that person probably isn't allowed to stop the officer. And then you run into this question: can the AG's office actually enjoin the ICE from arresting people in the performance of their federal function? Are we not again trying to regulate federal function? It's kind of where I run into the questions.
So we've had some testimony from the AG's office, and also looked at a Northern District of New York case that treats this somewhat differently, particularly in that instance. And there are more than just that case involving the similar kind of setup related to courts, like this, our current law, and has been upheld. And there was an executive order actually in New York that specifically targeted immigration enforcement in state facilities, which were buildings wholly or owned or in part. And that was upheld because there's the state interest in the property. So that's one thing. And there's also state interest. And this wasn't directly in that particular case, but it was kind of alluded to, if I'm recalling, as far as core governmental services, that if they're being provided, that the state has a lot more authority vis-a-vis the federal government. So that's kind of, it's a little bit different than, we'll see how different it is, because if this gets all the way through.
So it's not on appeal to the circuit?
It hasn't, that case is not, I don't believe it's been appealed. I'd have to double check.
Okay.
But yeah, I mean, so this will inevitably be litigated, almost certainly. And the question is what kind of arguments we have. And we've heard that we have some different arguments here than we did, with respect to 208.
Right.
So.
And my only other practical concern then would be, to the extent the AG's office is supposed to seek injunctive relief for individuals in this situation, it's it's my understanding they are severely resource constrained to the point where they aren't even prosecuting cases in their criminal division. They've already got a caseload of probably about 50 federal cases. They have asked for more people but I guess a question is, if they in fact are resource constrained, how much does this add to their burden, which I guess would concern this committee?
Yeah, that's always a concern, and thanks for raising that as well.
Yeah.
Angela.
And to your question about what is like the, reception staff or, others who are just in the lobby or whatever
Right.
of a state building, what are they supposed to do? My reading of the bill is that there's not an expectation placed on them to
Right.
enforce this in any way.
Right.
And I think about, schools, most schools don't have security staff. Most libraries are not gonna have security staff. A lot of the places on this list and don't have those.
Right.
That personnel.
Right.
So just to be clear that there is no expectation on folks inside state-owned buildings
Right.
to be, enforcing the law.
Right.
It's really more in those cases, if the hypothetical you shared were to happen, I think, the law is in place for remedy after the fact.
Sure. And the other question, I guess, so say you have the Capitol Police, and this happens, and the Capitol Police do nothing. That's your expectation.
What was it?
So an ICE agent walks through the building, with the understanding that there's a person here who may even be walking out of a committee room. They arrest that person with an administrative warrant and they go to exit the building. What is Capitol Police supposed to do?
I think that I wouldn't place that expectation on the police. I would bet there's a good chance that discussion has perhaps even already been had by the Capitol Police.
Just as long
So it
as
would be whatever
there's no expectation.
There's no expectation for anyone to interfere. I think the guidance, even, in like the bill that we discussed yesterday, the school guidance, there's no one is saying that I've seen, that I haven't seen any guidance to any entities saying it's your job to stand in the middle of this.
Okay. So that's an answer to questions that have been raised. It is this, of course, we all know there's legally no expectation, but there is often an expectation. Just right. So, but as long as that's clear, there is, and again, I just question the if this intent is to help people feel less afraid, whether this in fact raises false hopes in a way that, practically speaking, will not do anything.
I think I just have a question. So two things. One, do you think someone could challenge the validity of the arrest if they were to be taken in one of the locations that they're not allowed to just use an administrative warrant on, and they're arrested?
Maybe in state court. But at that point, there is a federal immigration proceeding, and that person has been arrested for a purpose, right? You obviously, not obvious, it should be obvious, not always obvious, that there is probable cause to obtain the administrative warrant. That's what Second Circuit has held. So you have to have probable cause. Same for a criminal. And then you arrest that person. And whatever that, it could be the person that has a felony for reentry and it's a final order and they have refused, right? So it's kind of the federal government has made a legal arrest in the course of their federal duties under federal law, and they are going to be proceeding in immigration court or some other, and if they have a challenge otherwise, right? Obviously there are cases that are going to go to the district courts. But generally speaking, not generally speaking, that could be those kinds of outcomes, right? You go to a federal district court, or you will end up in a federal immigration detention facility and going to immigration court. But you may or may not have counsel. And in Vermont, you may well have counsel. And so you will be you'll be experiencing that. And you may have a case that will be untested under this law to argue that under this statute, your arrest was unlawful because you were on your way into a school,
Not any, oh, yes.
right? And so then I mean, so that's your argument. You have representation, and the federal government shows up and says, this person was exercising their federal authority under lawful, I mean, federal jurisdiction, federal authority, lawful, legally obtained warrant. Okay. I mean, I guess I don't know how that plays out in court. You can ask all the other litigators who have been in this chair, right? I would just be curious about how strong they think that state legal argument is. And ultimately, you could get punitive damage and reasonable costs and attorney's fees from the federal government. I kind of doubt that that's viable, but I'm not a litigator. I would ask the AG's office, obviously has testified, and others, ACLU, can testify on, how likely that claim would be. It's succeeding.
Any other questions for Jay? Guess not.
Thank you.
Great. I think it will adjourn for the morning, and I think we will be back this afternoon after the floor. I'm not sure what time, but I'm gonna guess 2, yeah.